David Whiting, good morning to you. Welcome to Mernda.
Thank you, John.
Is this on your regular path at all?
Well, today's fantastic because I have a meeting this afternoon in Wallan.
Oh, perfect.
So I'm going to go from Mernda to Wallan.
Excellent,
so
excellent.
That's working.
And you can go fairly slowly then if it's this afternoon.
It's just this afternoon, so there's a bit of time.
You haven't got time to go back into town and come back out again?
No. The bit I went and looked for a property on the way out here this morning because I made an application to bring land under the Transfer of Land Act probably 25 years ago. And there were 2 SEC easements running across the land.
Big power line things?
No, but one was for a single wire.
What?
So what had happened was, I think the first hydro scheme in Victoria was at Rubicon, and the SEC took a very narrow easement to run a very narrow line all the way to
one wire on a pole?
I think it's two wooden poles rather than those huge KV8 towers, and right next to it, you now find these very large towers. So I had a look this morning. There's still 2 relatively small poles and 2 incredibly large towers. But it's fascinating the history that you see from just looking at the circumstances that gave rise to the easement.
Yes. If you have a look online, Simon, our online reporter, just showed me this. He's assembled a time snapshot over time from Google Maps of an aerial shot of how the area has grown. So if you go to ABC online, and there's a story there about housing affordability and our visit to Mernda, and in there, embedded is this little timeline photo showing it's taken from a satellite, so it's all rural, and then over time as the timeline moves along, you see the growth, the subdivisions and the houses growing in front of your eyes.
It'd be fantastic.
Yeah. Quite startling. All the same.
Now, John, I had a couple of things for you this morning.
Sure.
Do you read the terms and conditions when you hop onto somebody's Wi-Fi?
No.
Oh, well, in 2014, a firm in England put in the Herod clause, that the terms and conditions required you to surrender your firstborn child.
Yes.
They did point out that it was not enforceable.
Yes.
Last year...
But this was just a little in-joke for the fact that no one ever reads this stuff, and how could you?
Well, earlier this year there was a crowd in Manchester that provides IT hotspots for cafes and restaurants. And it included a condition obliging the people who signed up to do 1,000 hours of community service. 22,000 people have all signed up and agreed to do community service.
Well, I mean, imagine if renting a car. You can't stand there at the counter, typically at the airport, reading out the fine print of the terms and conditions. And what's the point anyway? They're not negotiable. The people who are behind the counter don't have permission to change them or vary them. So what's the point anyway?
Well, you could accept but isn't the view that if it's free, you're the product?
But if you're signing up to something,
yes.
But I'm saying what's embedded in the terms and conditions, you can't, even if you can read them, you don't understand them, and then you can't vary them. So what's the point? You either want to hire the car or you don't. If you want to hire the car, this is what you've got to sign, and you can't discuss it, negotiate it, or vary it.
Well, talking about contracts of adhesion and contracts of bargain, there was a Court of Appeal. There was a full court decision in the Supreme Court last week. Imagine, if you will, you sign up for a SIM card for your mobile telephone service.
Yes, just did that. I was held prisoner in a phone company shop for 3 hours the other day.
Okay, right. Good luck.
Well, my phone was broken. I had to get it fixed. It took 3 hours.
Well, then what happened in this particular case was this man went travelling, and overseas his SIM card was stolen. The people who stole the SIM card signed up for a whole series of services, and in the 20 hours before the card was cancelled, he was billed for 1,161 hours of calls to an organisation basically in Latvia. So
I wonder what sort of services they provide.
I don't know. What got me was that the telephone company thought that he should pay for them. So it's an accusation.
To a total amount of
$34,500.
Oh, of phone calls. $34,000 worth of phone calls.
Well, and SMS services and all the rest of it. So thankfully the Court of Appeal found that in his particular case the services for which he was billed weren't covered by the definition in the contract.
Good.
So but what that tells me is they're just now going to go and fix the contract, John.
Yeah, but the judges will keep finding ways to help people when occasionally one of these cases make it to the courts.
And a glorious story out of the United States. A group of police raided a medical marijuana shop in California where it's legal. And what they did was they systematically either removed or broke all of the closed-circuit cameras that they saw. And they then caused some damage, and then they stole things. So what happened was there was a backup security system they didn't see. And the backup security film was used in disciplinary proceedings against the police, and their view was that that interfered with their right to privacy.
Sorry, can I just get this right again? The police raided a legal business,
Yes,
which is selling marijuana, which is completely legal.
yes.
They then moved the cameras so they couldn't be filmed
No, they destroyed some and took some away.
in order to then commit
A crime.
a crime against the owners of the shop. The
Yes.
police
Yes.
were doing this against
Yes.
the shop owners.
Yeah, could we call it the police members rather than the organisation? But yes, right.
And then, when it turned out there was another secret camera
Yes.
that filmed the police committing crimes,
Yes.
they said, hang on, that's an intrusion.
Well,
on
their
our
view
privacy.
was that was an unreasonable intrusion of their privacy, and the evidence obtained by the security cameras should not be allowed.
Please tell me they lost.
They lost.
That's good.
Okay, but it took 3 years for them to lose. So, yeah.
In the
fortunately
meantime,
they
no
did.
doubt, they stayed on full pay, arguing that it was all a gross miscarriage of justice
It's
and
only fair
infringement of
thing,
their
John.
rights. Yeah,
The only fair thing.
but they I hope they were all thrown out.
And we had a caller last week, Don, from Doncaster, who had bought a property and then found that the fence was out by about 300 mil.
Yep.
And the question was, well, what is the contract, the standard contract of sale that we all sign, under which we buy land in Victoria? It's the standard condition under a contract that's designed to provide a fair balance between the rights of the vendor and the purchaser. And it says that an omission or mistake in the description of the property or any deficiency in area, description or measurements does not invalidate the sale, and you can't make a claim for compensation.
Oh, and that's the end of that then.
Well, it is, but it doesn't strike me as a fair balance between anybody's rights.
But it is the way it works. And just briefly, we'll get to callers in a second. Front page of the paper, a man convicted of killing 2 police officers in company with another man back in 1998 is saying that there's fresh evidence. There are doubts about the conviction. He wants a petition of mercy considered by the Supreme Court of Appeal, and the Attorney-General this morning has said absolutely not. I'm not exercising my discretion in your favour. I don't think there's anything particularly compelling about this here. How rare is a petition of mercy?
Incredibly, because it's entirely discretionary. There is absolutely no obligation to even consider it. When you get a letter, you can't not think about it, but you're certainly under no obligation to deal with it. New South Wales have developed, I managed to hear your conversations with Rob Starry and with Martin Pakula.
So that's the lawyer for the convicted man
and for the attorney.
And the Attorney-General of Victoria.
And what got me was that in New South Wales, where we're concerned, everybody's concerned about the quality of the administration of justice, is that they're actually developing a commission that will, in fact, its sole job will be to review what are apparent miscarriages of justice. There will always be some, but as few as you can get, the better. My observations just on listening to the conversations were that this is evidence that was available and not used. And to that extent,
for whatever reason, the defence chose not to do it. No, we can assume here, I think quite safely, if you call a witness to go into the witness box to say something in your favour, then that witness will also be asked questions that could be to your detriment.
Yes.
So you are very careful about putting a witness in the witness box whose evidence could backfire.
Yes.
And you can't edit and cherry pick witnesses' evidence. If they go in the box, they can be asked anything.
Pretty much, yes.
So if they chose not to put his then girlfriend in the witness box back in the 1999 or whatever it was trial, it's because they were worried about what she might say that was to their detriment, not just what she might say that was to their favour.
That's certainly what we assume, but it's not new evidence.
No.
The other thing is that appeals to the Court of Appeal, even 17 years ago, you have the right to make an application for leave to appeal. The High Court says, look, our role is to define the law and in that way do justice to people. It is not our role as it used to be 20 years before. I mean, there was a time if you got sent to a period of imprisonment, you had a right of appeal. Now you've actually got to argue that there's a principle of law. And this, to me, was not the law, it was the facts.
All right.
Yeah.
Let's get to calls. David Whiting, our talkback lawyer, and Roger in Red Hill is our first caller. And apologies for leaving you waiting so long, Roger. We had a lot of traffic to get through, just like the people of Mernda do in the mornings. Good morning to you, Roger.
That's okay, thank you. David, I just want to ask you about if there's any legal facility to quantify pain and suffering. I had an accident and I'm having a discussion with the insurers who presumably want to avoid headlines such as elderly man savaged in midnight attack by homicidal pantry in rural kitchen. A pantry roared out, a motorised pantry roared out of our newly fitted kitchen at midnight and
it sounds to me like you've got too much money, Roger.
My arm.
How can you have a motorised pantry?
And broke it.
Roger, Roger, whoa. Roger, stop. What is a motorised pantry?
Well, this is modern life, John. You touch a face of a pantry with no handles, and it activates a sensor, activates the motor, which then pushes the pantry out into the kitchen so you could access the shelf.
You're pulling my leg, surely.
No, seriously. No. This is big deal stuff. And then you
so
it's
more expensive than handles.
It closes.
It's a robotic pantry.
It's sort of, yeah. Except it has problems, obviously, when it goes mad. And it took a dislike to me for some reason just after midnight, just before Christmas, and came roaring out of the wall, disconnected itself, didn't stop. Elderly men do stupid things, you'll learn, John. Put my arm up to stop it, and I got trapped between the bench and the pantry. Broke a bone in my arm. So
I'm sorry to hear that.
Christmas.
Oh dear.
Yes.
So is this a question about the pantry or about the insurance?
The insurance company has been pretty fine. I've never had an apology from the company concerned, but the insurers have been in touch and they've covered. I'm a farmer, so a one-armed farmer for 6 months can't do a great deal. So they've covered a lot of the costs, but they want to now bring now I'm legally or medically healed. I had to have the arm opened and plated and screwed and all sorts of things. But now I'm finally finished with a minor limitation to the rotation. The insurers want to discuss it with me with an aim to coming to a mutually agreeable settlement, obviously to avoid publicity and litigation. And you guys are always warning us, avoid litigation at all costs. But what I've got to decide is what's a reasonable compensation for an open surgical operation, anaesthetic, in hospital, just travelling to and from the city for medical appointments, CityLink costs, parking costs. They obviously want to pay as little as possible. I want to get as much as possible. So we're back in that old
from the wrong premise, Roger.
problem.
You only want what's fair.
Well, yeah, what's fair? Is there some way you guys set up a fair compensation?
There's no formula for fair. Fair really because the pain and suffering that you feel is going to be unique. So it's a litany of all of the things that you've done that you've been put out by, and how long it's all taken you. So you would normally get doctor's reports and the like. Yes. Have you seen a psychiatrist? Have you taken medications for pain? All of those sorts of things.
Roger, I've just been looking on the internet for motorised pantries.
Yeah.
Yes, and I can't find any. I wonder if you're making all of this up.
No, John, I wouldn't do that to you. The sands in my hourglass are running out rapidly, so I haven't got time to make jokes. No, this is serious stuff. It does exist. I'm obviously not mentioning their name because it's not fair.
No, don't. I found motorised shoe storage.
Yeah,
I can't believe that exists either.
And it's sold in Melbourne.
Really?
But they had a big meeting in Europe over me because this was a unique event, meaning literally unique. and they got all their experts together in Europe to discuss this issue. I haven't heard any result from that, but they're still selling the pantry, as far as I'm aware.
Look, I'm really hazardous to put a guess, Roger. I would be going off and talking to a lawyer about what it might be.
Yeah, but
you might talk to one of those people who do...
cost
Beg your pardon?
money.
Yes, they do cost money, that's right. Yes.
So
I reckon if you can afford a motorised pantry, you can probably afford to consult a lawyer too, Roger.
And look, I'm quite sure at free my comments are worth every penny, Roger, but I'd actually rather that you went and got someone who was able to give you a more fulsome analysis than we can.
So
I think we've taken it as far as we can this morning, but Roger, you've made my day. Even though I'm out here in Mernda at the bakery, I'm fascinated now by motorised pantries.
keep
All
checking.
right.
You'll find them on the internet, John.
Well, I've started searching. In fact, my
Doing a renovation, John?
no, not at all. I've been there, done that, never again. But I'm astonished that such a thing exists. Roger, good luck with it.
It's all right.
Sorry we can't be much help, but yes, you need to get legal advice. Dorothy in Geelong, good morning to you. You're through to David.
Morning,
Have you got a
David.
motorised pantry, Dorothy?
No, I haven't.
Oh.
I'm an
Do you
avid
feel like you're
listener.
missing out?
I'm an avid listener, but this time I want your advice.
Excellent. Go right
I'm
ahead.
very concerned about the height of crowded large trees growing against the 4'6" dividing wooden fence of 8 flats, they're 2-storey, next door, which have been let grow wild, high above my roof and guttering.
I take
The
it we're talking about
flats
the
are
tree,
built-
not the flats.
The flats are built right over the other side, so they're all right.
Yes.
I have new decking running parallel to the fence, which is approximately 6 feet wide, so the proximity of the trees are around 6 feet from my house. Every day I pick up leaves from the decking. In early April this year, I wrote to the manager of the body corporate in Melbourne to express my concern. I mentioned having had new extensions to the front and back of my home, formerly my parents' house 44 years ago, that I have new sewerage pipes installed to prevent tree roots from invading our sewerage system, an ever-recurring problem, and I paid $2,810 to All Clear Leaf Guard in Melbourne to protect my guttering. At
How
Christmas I
can we
paid...
help you, Dorothy?
You can't...
What is it you're looking for?
I don't know what to do. I have written to the body corporate manager. He has done nothing. He hasn't even written back. I rang and I was transferred to a lady who said I needed to send photographs. I sent 13, along with a letter dated on the 26th of April to ask what the manager intends to do, remembering that the flats will
Dorothy.
be responsible.
Dorothy, your issue is the trees and what the damage they're doing to your property.
What can be done if we have a lot of heavy rain, yes.
What will
With the
happen in heavy
leaves.
rain?
Well, the leaves could clog the guttering and...
Dorothy, the law operates on a fiction.
Yes.
And the fiction is that it assumes that everybody's trees are on their property and none of the roots spread, none of the branches spread and none of the leaves drop. You have the right to require the owner's corporation that owns the property next door
Yes.
to remove their roots from your property, to remove their branches from your property and to remove their leaves from your property.
That's not
But
the problem, it's
on
the
one
height.
level,
It's the height of them that is well over my roof and, of course, the guttering. And it's the guttering that worries me. Yes, I have paid to have leaf guard put all
yes,
around the guttering.
Same issue though, the same issue. And it doesn't. The answer is not how high the trees are, but whether you think the trees are a danger.
I do.
I mean,
That's
I
the
would
thing.
describe the leaves as an irritation,
Yes.
and I would describe the leaves as an irritation. You
Yes.
have the right to go to court to get an order
Yes.
that they come and clean them. But you're going to get to the point where every time you go to court it's going to cost you a great deal more money,
Yes.
even after getting a contribution to your cost from the other side. I think it would be why would you not go back to the owner's corporation manager and say, you
I
will
haven't
be
even
visiting
spoken
this
to him.
property.
Yes, he
You
hasn't
will be
even...
visiting this property,
Yep.
and when you do, would you come and see me because I have some concerns about the trees?
Dorothy, I'm
and-
not sure we can help you much more than just that advice today. And I understand that causes you some anxiety, but I'm not sure we can help you anymore.
No.
More callers in just a second. David, I've got any number of people now sending me links to YouTube clips and ads for different motorised pantry suppliers, and I'm even told I need to get out more and go and see some display homes because these things are state-of-the-art and now being offered as part of bespoke kitchens.
And clearly, John, I did a renovation 7 years ago, so...
I need to get out more.
You do.
Yep, undoubtedly. Rebecca in Hampton, good morning to you. You're through to David.
Good morning. I think it's a small question. I sent a parcel using a parcel delivery service for an item that was purchased from me over Gumtree, I think it was, or eBay.
Yes.
On
So
the
it's
front
a sale by you rather than a purchase by you, is it?
It was a sale by me. I popped it in the post using this parcel delivery service, and on the front you tick whether you want the item signed for signature on delivery, which I did. A few weeks later, hadn't thought about it, I got a message from the purchaser who said it hadn't arrived.
Yes.
And I contacted the parcel delivery service to let them know that, and they said, "Oh, we're sorry, that didn't happen." According to the tracking, it was left at the doorstep, so it wasn't signed for.
Yes.
I'm wondering whether the parcel delivery service is liable for the contents.
There will be some terms and conditions of the parcel delivery service, and I know that the major parcel delivery service in Australia, called Australia Post, does not guarantee that a parcel will be signed for if you've ticked that box.
Okay, this wasn't
They don't
Australia Post.
Well, no, but I'm saying if the major player has a condition in their standard terms, which doesn't actually commit to getting articles signed for when you tick the box, I don't see that anyone else would.
Okay.
So you can go to the website and you can see what their terms and conditions are.
Can I read the line to you?
Sure.
Delivery. The carrier shall be deemed to have delivered the goods in accordance with these conditions if the carrier, 1, obtains a signature acknowledging receipt from any person who presents themselves to the carrier as the receiver, or 2, is provided with a written authority to leave, which can be either permanent or on a per consignment basis.
Then you will have a claim against the carrier, but your claim against the carrier will be limited to the amount you insured the goods for.
So they have to be insured, do they?
Well, again, if you keep reading the terms and conditions, their loss will not be unlimited. So if you put in a 5-carat diamond and didn't insure it, so the issue will be, and it might be a nominal $20, $30, $50.
They've got limited loss up to $1,500 in these terms and conditions.
That sounds a more generous deal than I've ever heard.
Yeah, and the item that I sent was hardly worth that at all. I'm just wondering whether it's worth pursuing it.
Well, I would. They promised to deliver it and they didn't.
Well, they did deliver it to the doorstep. That's their point, but they didn't obtain it. But they didn't obtain a signature.
Having ticked the box on what you read to me, their obligation was to get a written acknowledgement or a signature, and they got neither.
So where does Rebecca go? Do we go to VCAT on this?
Well, you could go to VCAT, but in the first instance, I'd go back to the company.
Sure, and then when they say no, go away, you then have to...
How much is the value of the goods, Rebecca?
A couple of $100, not a great deal.
Well, you're going to spend a day of your life and $50 or $60 at VCAT.
Yep.
For what may or may not get you the result you want.
And they've also asked for evidence of the fact that I ticked the box when in fact the evidence is on the parcel in question. The only evidence of the ticked box is on the sticker on the label.
Which is therefore gone, so it's your word against nobody. So you could be quite convincing there. Do you want to invest that much time in going for a couple of $100 to VCAT, Rebecca?
No, probably not. I just feel bad for the purchaser who paid the money and hasn't received anything, and I think, well, I'll just refund him the money instead.
Yep. And for anybody else, if you're going to send parcels in those circumstances, take a photo of the label before you send it off.
Yeah.
And this is with the new economy, and Rebecca's a classic example. There are so many of these issues. I was walking the dog the other day and saw a bloke jump out of a van, take 24 bottles of wine in boxes and just put them on someone's doorstep. And
Were they any good?
Well, I didn't take them, David.
Okay,
thank
sorry,
you.
John.
But I thought, it wouldn't take much for someone to do so.
Uh-huh.
And yet that's said to be delivery. So this is rampant now, the online shopping and delivery parcels.
Lots of parcels you get are marked actually No signature required, please
Yep.
leave.
Yep.
Yes.
And sometimes, you arrive and you get a little card under the door saying your parcel is behind the rose bush or in behind the couch, whatever it might be.
Or at an office building that's not acceptable to you at the time you want to get access.
Yeah, which
Never
can
mind.
also happen. Rebecca, good luck. Can we squeeze in one or two after the news headlines? David Whiting, our talkback lawyer here at David Whiting, our talkback lawyer, helping you with free legal advice. And John in Seaford, good morning to you. Thank you for holding.
John, how are you guys this morning?
Well, thank you, John. How can I help you?
Good, mate. I just point of clarification. I was a respondent, went to VCAT, right? Went through the mediation, and then it got to the directions hearing, which the member said, this is the final, somebody's going to be happy or unhappy, but nevertheless. So the other part didn't want to mediate. So cut a long story short, I went, and if there's winners and losers, I won.
Yes.
What I want to know is that's the final outcome now, isn't it? End of story. It was the final directions hearing.
If there
bang.
was a decision made by VCAT, it's final, unless the VCAT member made an error at law, and then the party who is upset by the decision has the right to go to the Supreme Court, but only on a question of law, not on a question of fact. Yes.
Okay. Just to clear that up, when he gave the when we got the back in writing, it said claimants, whatever it might be, dismissed completely as the reasons given orally at the hearing. So what I've done now, I've sent off to VCAT and hoping to get back a copy of that oral. Is that reasonable?
In fact, there's a provision for it in the VCAT legislation and on the VCAT website.
So I'm right in saying that if it's
It's got
given...
to be worth a lot of money before anybody bothers going to the Supreme Court over a VCAT appeal.
Oh, absolutely, John. It costs
Minimums.
I would have said I would allow $30,000 or $40,000 to start.
Minimum.
Yes.
Yeah.
John, so VCAT being a small claims and simple claims jurisdiction, not many cases warrant Supreme Court appeals.
No. So
John,
the answer,
you can get it. What you might just want is the audio and transcribe it yourself.
that's what I thought.
But
Yeah,
there is a process on the
act.
in the Act for getting it. In fact, if you turned up at VCAT, every room has signs that says, the microphones are on in this room between this hour and this hour. Even when a matter's not being heard, they only turn them off when there's a mediation proceeding.
Okay.
So, John, you
excellent.
should be able to get your recording.
Alrighty, good on you, John. I hope that helps you. Got a text message here from Jordan the courier.
Yes.
Half my day is filled with delivering boxes of wine. No signature required ever. Leave at the front door. 70% of deliveries are marked ATL, authority to leave. A lot of people will say if you need a signature, just do a scribble and leave the parcel. That's all good until something goes missing, and then who gets the blame? I know what I'd be doing if I was still 16, says Jordan the courier. Someone else says
He
that
wouldn't be taking wine bottles.
the
around.
reason the wine doesn't get nicked where I'm walking the dog is because nobody where I live needs to steal wine, which is absolutely not true, I can assure you. And couriers ought insure up to the first $1,000 is another text message. There's nothing automatic in a courier's contract about that,
None
is
at
there?
all. No.
And if you get what you pay for, so if you hire cheaper couriers, they won't have insurance. If you want insurance, you pay more,
But it's back to where the conversation started. Read the terms and conditions.
which no one ever does.
No.
Peter in Lower Templestowe, thank you for holding on, Peter, and sorry about that, but I'm glad we got to you in time. Good morning.
Yeah, good morning, John and David. You had a few curly ones there this morning. Mine should be fairly simple for David. A title certificate issued in 1908, I think it was, by King George V.
Yes,
I think it was
personally.
called a land grant
Yes.
or something. And the title certificate,
Crown
the
grant,
original
it's
one
called.
says 100 acres more or less.
Yes.
What does that mean in legal terms?
Well, it'll be overcome by the way we define things now. But think of what happens if you buy 100 acres with a hill in the middle. How much land do you actually get? What's the surface area? What they're doing is they're allowing for discrepancies. In conveyancing transactions, it used to mean 2 inches in 60 feet. All right? So there was a defined, the Property Law Act contains a provision that says when there's a description in relation to land, there is implied in every description an error of 2 or 3 inches in 60 feet. So you look at the dimensions of the While it might say containing 100 acres, 3 roods and 2 perches, it will actually be, the dimensions of the land will be defined. If you were to sit down and calculate the area within the map, that may or may not be 100 acres, but it will be close.
So back in the day when Peter's title was established, the precision instruments surveyors use now didn't exist, and so things were done as closely as they could get them to be done.
Yes. Yeah.
Does that answer your question, Peter?
Partly. We recently surveyed it unofficially, not by a surveyor, but
Yes.
can easily be done with GPS, and we've got 120 acres.
No, I would have said you might have 102, but I wouldn't have thought it would be any more than that. So if you're concerned, get it formally. But what you might also find, though, Peter, is that you're occupying some land by adverse possession. There might be some land that you have fenced that isn't actually part of the title. So you haven't surveyed the land in the title, you've surveyed the land within the fence.
So should
Correct.
Peter get a surveyor to compare
Yes.
what's on the surface of the earth with what's on the piece of paper that pretends
Yes,
to
because
represent
you may
it?
have an adverse possession claim against someone for 20 acres.
That would be the Crown.
Well, then you have no adverse possession claim against the Crown or a local council.
Because you can't have adverse
So are you
possession against
next
the Crown.
to a national park or something, are you, Peter?
No, not national park, but Crown land to 2 sides of the property.
Then
So the-
I'm really very sorry, no adverse possession against the Crown.
No, but Peter, you should just be very, very quiet and continue with exactly what you've been doing for however long you've been doing it.
We're doing exactly that. We've done it for 50 years, and the people before us did it then too.
Well, I think
Okay.
just don't tell anybody and keep going would be the advice, wouldn't it, David?
Enjoy it as long as you can, Peter.
And that, unfortunately, is all there's time for today. Ladies and gentlemen, could you thank David Whiting, our talkback lawyer, who has been joining us out here in Mernda. And David will be back in the studio at the same time next week. And David, enjoy your tour around Mernda and your meeting this afternoon in Wallen.